The Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to before this court will draw near, give their attendance, and they shall be heard.
Very good. The first case on for argument today is case 162, People versus Baska.
Good morning, Your Honors. Brad Osler for the People. May it please the court. I don't believe my opponent's going to be appearing today.
Yes, you're arguing alone.
Okay. So I'll get right into it. Your Honor, this indictment was dismissed because of a purported lack of sufficiently corroborating evidence to support the grand jury testimony of an accomplice. Now, recognizing, of course, that this is a somewhat unusual count, perjury, and it's an unusual theory of prosecution, perjury by sort of conspiracy or with an accomplice, I think the standard set out by the Court of Appeals.
Mr. Osler, it's really a suborning perjury case, correct?
That's exactly right.
Okay. So in the suborning perjury, that would have happened on November 30th when the defendant testified, correct?
Yes, and I would submit it was continued at least through the following day. Because
who swore testimony on the first?
There was no sworn testimony offered in front of to the fact finder on the first. Obviously the testimony occurred by the defendant in that trial by this defendant's client in front of the jury on November 30th. However,
and when Mr. Baska said on December 1st, when they're discussing the missing witness charge, he said, upon information and belief, this Mr. Burke had died in Pennsylvania on such and such date, correct?
I think it's essentially words to that essence, yeah.
I'm sure you know where I'm going, is that when we look at the court's decision about harmonizing evidence, and your indictment is limited to the 30th and the 1st, as I understand it. Yes. So even though there's an allegation in the bill of particulars that something happened in the opening statement, I've got the original record or seen it in the Emmons case that's on for today. So I didn't see anything in the opening statement there. So it's all about what happened on the 30th and what harmonizing happened during or before Mr. Emmons' testimony, because wouldn't it have to be during or before?
I don't think so.
Okay,
I don't think so. The reason I say that is because, well, I could go back and say that I think the defendant was aware going into the trial that Mr. Emmons was going to lie on the stand based on their pretrial conversations and then his testimony at the trial that he was not in fact driving the car. He had initially indicated.
How do you know which story is true?
Well, we don't, except for the fact that later on, the events of December 1st, I think made it clear that the story that he was not driving was unsubstantiated because he had manufactured this individual that was not in fact driving, but suggested to the court that he was.
And I'm sorry, I got you off your argument. I asked a question, I didn't let you finish.
No,
but I asked you the question specifically about this issue before us about the harmonizing, because that seems to be what the court dismissed on, is the absence of evidence before the grand jury of harmonizing. And my guess was, without seeing any just brief by the other side, was that the harmonizing needed to occur before or during the testimony of Mr. Emmons, because there was no sworn testimony the following day. So can you address that? I think you answered that you didn't think it had to be before or after, but how do you get to that point?
Sure. So the circumstances of this are interesting just because it's a trial. So we have the testimony occurred on the 30th, and then we have a bunch of follow-up conversation that's very relevant presented to the court on immediately after the testimony and then the following day. So the harmonizing.
What happened that night of November 30th? There was the phone call.
Correct.
Auntie's number telling him that I screwed up, the person's dead. And did he turn in the next day the death certificate even after he had gotten that call?
That's our contention, essentially. Yes. So we have Mr. Emmons calling defendant after his testimony on the evening of the 30th, saying I screwed up. I sort of backed myself into a corner here. The call disconnects. There's the second call, and the phone records obviously substantiate that. And the phone.
I'm sorry, but can you? My question fundamentally is: can you suborn perjury after the fact of the perjury?
I think in this instance you can, because defendant, by his continued actions on the first, when he presented the obituary for the Burke who, I think everyone was aware was not connected to the Syracuse area, had no connection to defendant, certainly wasn't involved in the driving of the vehicle. The presentation of the obituary and the continued, essentially attempting to convince the court that that Mr. Emmons' testimony was truthful, that's the continuation, essentially, or the continued suborning, perhaps, of the perjury. It is. I don't think we can separate logically the idea that an attorney or defendant in this case can sort of be absolved of any sort of risk of being an accomplice in this sense, based on his actions after the testimony is completed the following day. He took straightforward affirmative actions to continue to try to substantiate his client's testimony, which he knew at that point was inaccurate.
That's your theory of private prosecution, is that the harmonizing can occur after the suborning can occur after the testimony.
Yes, and
so that's your theory, and you're going to stick with it.
It is, and I'll note also that I think part of my argument here is that the harmonizing, at least as far as the accomplice testimony, or as far as evidence that would support a conspiracy conviction, the harmonizing evidence doesn't even need to necessarily be at the time, as I'm arguing, doesn't need to be at the time of the perjury. We have the phone records that substantiate Mr. Emmons' testimony that backs up his story. And we have the obituary itself. We have the people's efforts during the December 1st to try to determine if there was this other individual.
Mr. Rochester, we all know the record very well, and I got you down a path that probably has more to do with the prosecution ultimately than whether or not you met your, I think what some would perceive a relatively easy burden before the grand jury to say that, okay, our theory is the harmonizing occurred after the testimony. This is a legitimate theory under the law, and therefore these facts with the phone calls after the testimony support our theory under the law. That's basically what you're telling us, I understand it.
That's exactly it. And I submit that is the correct analysis, only because the standard in Reom, and I understand the court's aware of this, but the standard in Reom is not burdensome. It just needs to be, they have language about, trifling issues essentially to corroborate an accomplice testimony. We have more than that. We well exceeded the minimum bar that's required. And I don't think it really matters that harmonizing evidence or that corroborative evidence occurred the following day, occurred after the perjury took place. In this context where the perjury had a lasting effect essentially through to the end of the trial, the continuation of that is essentially one and the same act. And that's why it's a theory of accomplice liability, a theory of conspiracy, rather than trying to suggest that defendant actively took the stand and offered sworn testimony, which he obviously didn't. But his continuation of his client's testimony and or his attempted substantiation of his client's testimony, that's one and the same. It's certainly sufficient for prosecutorial purposes.
Okay, Counsel, I think we have that argument. Anything further?
No, that's it, Judge. Thank you.
Thank you. Case 163, People versus Figueroa. And I am recused from this case.
Good morning, Your Honors. May
Hang
it please the court. Helen Syme on behalf of Mr. Figueroa.
on 1 second, okay?
Okay, sorry.
Okay, I think Ms. Gray, you're all set now?
Good mornings, Your Honors. Yes, thank
Okay.
you.
Okay, you can proceed, Counselor.
Thank you. The multiple errors by counsel in this case are particularly harmful to Mr. Figueroa because not only did they damage his position at trial, but they also eliminated his suppression arguments all in the same submission.
Let me try to help you out because, you know, the record's a little bit confusing, but this is what I understand. The first attorney withdrew, but then the court seemed to make a ruling at a later time. It seems to me that one of the confusions with the second attorney is this issue of untimeliness of filing the second motion to suppress. But I didn't read the record that the court gave him permission to file a second motion to suppress. I thought the judge was talking about the bill of particulars. And then when the court did give a ruling on the timeliness, I read that to mean the timeliness, the statutory timeliness from the beginning, not on the, you know, the confusion on whether or not they were going to be allowed to file a second motion.
My understanding is the extension was for both a argument on the bill of particulars as well as any other arguments that counsel had outstanding, and the court's decision.
What if we don't read the record that way?
In that case, Your Honor, it would be the submission of the damaging information contained in his affidavit, which could certainly be used against Mr. Figueroa at trial. It essentially established not only that he was a social guest in that residence, but had further connections to the building where the drugs were found. The affirmation did.
What was the effect? I understand. Your point is look, if he wasn't allowed to file a second motion, then by putting in this affidavit, there was no reason for it. And now it's given up the fact that he lived there, at least in the upper flat, right? But didn't the first lawyer already make arguments and sort of disclose and acknowledge that he had the right to keep his belongings in the basement because he was trying to establish standing?
He made admissions that the defendant had some property in the basement. There's certainly nothing in the record that said it was, you know, how long it had been there, was there with permission from the owner, or that it was his building. But it simply said he has some stuff there contained in the basement. But these admissions here went beyond that and took what could be a defense that he was just a social guest at this house with perhaps some remaining belongings from sometime in the past to he actively lives there right now when the substances were found, which in a case like this, if you don't get suppression of the evidence, is the only realistic defense. So not only did he file papers late, but he eliminated his client's chance at defense and weakened his plea bargaining position all at the same time.
Your argument would be too that if he wasn't allowed to file a second motion, even if he did it, you know, if we read the record differently, why would he give up this affidavit then?
That's correct. And it also allows the people to establish by the defendant's own words and admissions that it's his home, which I believe is substantially damaging.
Okay, I think we understand.
Thank you.
Welcome. Ms. Gray?
Good morning. Lisa Gray for the people. Good morning, Your Honors. And Justice Carney, with respect to your inquiry about whether or not the court granted an extension to file motions or supplemental motions, on page 5 of the, I believe it's the May 10th transcript, the court, you know, basically says this is for the bill of particulars. So if the court wants,
it was. I could see it could be a little confusing, but I just read it that he was going to have an opportunity with the bill of particulars. I know the lawyer was trying to get in. Hang on, we've got some suppression issues, but I didn't think the judge bought into that. And then I thought that when I read the ultimate decision, when the judge was talking about the untimeliness, he was talking about it in general, statutorily, not the untimeliness of this alleged extension or you know, granting of permission to file another motion. Is that your reading of the record?
I would agree with that, Your Honor. That is my interpretation and reading of the record. And I would impress upon the court too, though, that this claim of ineffective assistance of counsel certainly didn't infect the plea bargaining process in any means.
Let me get to that for you. Let me ask you the tough question. So
sure.
reading of the record is you couldn't file this set of papers. And in this second motion, there was an affidavit that I lived there. What was the purpose of that? And his defense counsel says that that was so damaging that now he really didn't have a defense anymore. So he had no other choice but to plead guilty. And therefore, the ineffective did infect the plea.
Well, two things, Your Honor, with respect to that affidavit. I think, as you had referenced earlier, it was a little bit confusing in that colloquy. So perhaps the defense attorney did think that he was able to revisit the issue of suppression. So he supplied that affidavit. There is a reference in the transcript that he, after reviewing the voluminous discovery, the attorney thought that at least there could have been a standing issue. But that affidavit in and of itself does not by any means eclipse a trial strategy on the part of the defense. I mean, that at trial, they could have made the people prove their case.
Yeah. The other thing we don't know if they were going to be able to establish, you were going to be able to establish it without, although that affidavit's pretty good without the affidavit. So that's something we wouldn't know, in other words.
Correct.
In other words, it doesn't matter. Let me ask you this. What about the idea that the first lawyer, what he did was he did say, because they're not complaining about ineffectiveness of the first lawyer, as I understand it.
I would agree with that, yes.
Yeah, he did admit, for purposes of establishing standing, I think that his client did have access to the basement.
Yes, I think he said that there were some of his client's personal belongings kept at in the basement, in some of the storage areas. So, I think the first attorney was trying to sort of hedge his bets somewhat in terms of how to attack the search warrant. Clearly, this was an eavesdropping warrant case. There was just a tremendous amount of information with respect to affidavits and discovery, and these were complicated search warrant issues. But the bottom line remains that even on the eve of trial, even after the trial court had suppressed or had ruled on the issue of suppression with respect to the search warrant, the people still came back and offered an even more reasonable plea bargain that the defendant availed himself of. So looking at the record as a whole, certainly there was no, counsel's actions did not infect the plea bargaining process. The defendant still got a very good benefit of the bargain. And for those reasons, unless there are any more questions, I would ask the court to affirm the judgment of conviction.
Any other members of the panel have any questions? I think we're all set. Thank you so much.
Thank you.
Calling case 164, People versus McLaughlin.
Good morning. May it please the court. Leah Mervine on behalf of the people. I would ask this court to affirm the judgment of conviction of murder in this case. And unless there are any questions from this panel, I would rely on our brief.
Any questions? No? Thank you.
Thank you.
Case 165, People versus Andre Jones. Very good. Counsel, please proceed.
Good morning, Your Honors. Jane Yoon from Legal Aid Buffalo. I just wanted to introduce to the court Kristen Markarian of our office, who is arguing this case today under a temporary practice order.
Very good. Thank you. Proceed, counsel.
Thank you. May it please the court, Kristen Markarian on behalf of Andre Jones. I'll be discussing points 1 and 3 from my brief, and the rest of my paper is remaining points unless the court has any other questions. Under point 1, the 6-person photo array presented to Mr. Diaz was unduly suggestive because Mr. Jones was the only suspect in that photo array with both a facial piercing and neck tattoos. Furthermore, since Mr. Diaz did not testify at the Wade, there should be a new trial preceded by independent source hearing. When looking at that photo array, Mr. Jones was the only suspect with a facial piercing going down the front of the side of his face. Although the detective that compiled that photo array testified at the Wade that she could have used blackout technology, she chose not to use it. Furthermore, Lieutenant Jones, who testified at the Wade, stated that she could see the facial piercing on Mr. Jones from the witness stand. In terms of the neck tattoos, the detective who compiled the photo array further stated that she could have chose other suspects with neck tattoos, but chose not to, and she still chose.
I'm confused. If a person makes themselves, you would have to find other people with Dominica across their neck. If you do your person with a tattoo that's distinctive, does that mean you can't ever be identified by a photo array? It wasn't like the person said, the individual who took my gold chain had a neck tattoo that said Dominica. He didn't claim that. That wasn't the basis for it. When you look at that photo array, I had a difficult time, and only after being aware of it could I see it. So I'm not sure it drew attention to it. I take it that's your argument that it did, though.
Your Honor, I would say that it did. Both complainants in this case included a facial piercing and neck tattoos in their description of Mr. Jones. And furthermore, they could have used the blackout technology on the neck tattoos to conceal it, or they could have chosen other suspects with at least other distinctive.
But if they use the blackout techniques to conceal the tattoo, then the person wouldn't fit the description of the victim who said they had a neck tattoo. So I don't understand if a perpetrator chooses to make themselves distinctive, that it's up to the court to make them undistinctive and perhaps render the ID unreasonable then. So I'm confused by that proposition.
Well, Your Honor, in another case of People v. Means, they had a defendant in that case with a distinctive neck tattoo. So what they did is that they used white tape on all of the suspects in the photo array to cover it up so that the neck tattoo wouldn't be the identifying feature. They also could have used the blackout technology.
There's no testimony here that Mr. Diaz said the neck tattoo was the identifying feature. He looked at the photo array and he circled that person. And if the neck tattoo was not clearly visible to him, then the ID was based upon the photo array, which the other 6 people did look remarkably similar and appropriate.
Yes, Your Honor. I would argue that the neck tattoo coupled with the facial piercing, and since Mr. Diaz did not testify at the Wade, it was unable to determine whether or not he looked to the neck tattoo. And furthermore, though, at the Wade, it did come out that Mr. Diaz did rely on both the facial piercing and neck tattoo in his witness description of Mr. Jones. So I think that distinctive tattoo coupled with the facial piercing and Mr. Jones being the only suspect singled out by both the facial piercing and neck tattoo would make the photo array unduly suggestive in this case.
I think we have that argument, counsel. Do you want to move on to your second point?
Yes, Your Honor. I would just also argue in terms of the way that there should be an independent source hearing based off of this way, just because Mr. Diaz did not testify. And at trial, Mr. Diaz stated that he didn't even know Mr. Jones's name despite spending the evening together. And that during this evening, Mr. Diaz was intoxicated. He was on a party bus with 30 other people going to multiple bars. And that he testified that all of these people were fighting when his chain went missing. So I would argue that there should be a new trial preceded by
it was backed up by his girlfriend saying he called, I need a cab, showed up with a new chain, said I took the chain. And then on the jailhouse phone calls, he talks about taking a chain. So there is more than just the identification of the victim about the chain and the taking, isn't there?
I would argue, though, in those phone calls, there's nothing ever mentioned about Mr. Diaz or any conversations with Mr. Diaz, and there was no identification that any chain or anything that was stolen was of Mr. Diaz. So I would argue that there is not enough information in the record for that to make that for that call in this case. And then, unless the court has any other questions, moving on to point 3 of my brief, I would argue that Mr. Jones should receive a new trial because he was excluded from 2 bench conferences, and that the trial court misled Mr. Jones as to the content of the first bench conference, which occurred on the second day of trial. And that second day of trial began with the people voicing their concerns about Mr. Jones's family and friends being in the courtroom, but nothing else further happened because they were not present. However, if you look at page 73 of the second volume of the trial transcript, you will see that in the middle of the people's direct, they stop, they are playing a video and they pause it, and they immediately ask for a bench conference. And following that bench conference, the people go on to a long colloquy of uncharged allegations of witness intimidation, claiming that Mr. Jones had been calling family and friends to stop witnesses from coming to court. And therefore, since Mr. Jones was accused of these uncharged allegations and not given the opportunity to at least impart his personal knowledge, since he was the only one with personal knowledge of those phone calls on the court, that Mr. Jones should be entitled to a new trial based on being deprived of that material stage and being misled by the court thinking it was just a scheduling matter. So I rest on my papers if the court has any other questions.
Thank you, counsel.
Thank you.
Counsel, please proceed.
Yes, Your Honors. Good morning, Mindy Van Leuven for the people. May it please the court. With regards to the identifications, Your Honor, it was confirmatory. The first person was his girlfriend. They were intimately involved, as was made quite clear in the trial transcripts. So that is no question as to how that was confirmatory. The second one was also, we would argue, confirmatory. However, we don't even need to meet that because there was no undue suggestivity within the photo array, as all of them were sufficiently similar.
Well, let me ask you something, counsel. Your opponent raises, I think, a pretty good argument and says, why couldn't we put tape to cover up just for example, the neck tattoo, and put the same type of tape on all of the people in the array? Why would that be onerous to do that?
I don't think it would be onerous, Your Honor, but it may be unnecessary. As the detective described, she went through a series of processes to try to make it she chose a photo of the defendant that made it as least visible as possible. She chose to present the photo arrays in black and white, which again, as the other justices had pointed out, made the defendant even more sufficiently similar to the other defendants based on the skin tone, but also as well as the neck tattoo. It made it less visible, as well as the piercing. You could barely see it because the photo was in black and white. So it would not have been.
I would agree with the remarks made by Justice Niemoyer. I looked at the photo array and I found it very difficult to really focus on those items, both in the piercing and the tattoo. But okay, your argument is that it wasn't necessary to do the covering with the tape, for example. So I understand.
Yes, Your Honor, it wasn't necessary. It wouldn't have been onerous. However, the detective did do other things that were not also onerous that made it less visible. So it's both confirmatory. There was no undue suggestivity. And without any other questions on that point, Your Honor, I will move to Appellant's third point argument. Both of those, held off the record conversations, the bench conferences. We don't know the content of those because they were held off the record. There was some discussion after the first one that talked about how the defendant was calling people from jail. So we have recorded phone calls, so we know exactly what they say. That was discussed with defense counsel. There's a place in the transcript where they talk about how those conversations were handed over on discs to defense counsel. So when appellant's counsel says, we have no idea what's in those conversations, only the defendant could talk to that. That's not true because they were recorded phone calls on recorded tapes that were turned over to defense counsel. And I believe at least one of those, there was a charge on, however, it wasn't pursued, I believe. So that was number one with regards to that. Number two is this contention was waived at trial when the court asked on the second one, up to this point, to the defendant specifically, up to this point, I assume you didn't care to be here, and the defendant responded right to his honor. So It's
The
way,
court said it was scheduling and other types of matters that he wouldn't necessarily have a right to be there. Isn't that correct?
I'm sorry, Your Honor, I didn't hear that.
It was my understanding the court said it was scheduling or other procedural matters. And then they went on to the record and had a full discussion about the intimidation.
I believe those were the two separate instances, Your Honor. I believe that that was the first instance that this occurred, and the second instance that it occurred, the court then stated, I assume up to this point you didn't care to be here, and the defendant responded right. However, those were the only two instances. The court did say something at that point. It wasn't even objected to by the defendant's own counsel. And the defendant then said, right, correct, I didn't want to be here. So I would also note though, however, Your Honor, a lot of times these conferences that occur outside the presence of the jury occur in open court, not actually physically at the bench. So I don't know that we can say the defendant wasn't privy to what was being said or what was being heard, or that his voice wasn't heard. Certainly his defense counsel was present at those bench conferences. And regardless, the defendant was specifically asked by the court, did you care to be here? And he said, essentially, no, I didn't. So that's all we have on those matters at this time. We have nothing further unless Your Honors have questions.
Very good. Thank you, counsel.
Thank you.
Case 166, People versus Emmons. Counsel, please proceed.
Okay. Good morning, Your Honors, and may it please the court, Sarah Goldfarb on behalf of Mr. Jeffrey Emmons. A material issue for the court to consider and for the jury to consider in this case was whether Mr. Emmons caused $250 of damages to the police car door. Yet Mr. Emmons was deprived his right to present a defense because the court struck portions of his testimony related to his decades-long career.
Ms. Goldfarb, good morning.
Good morning.
We have an unpreserved issue here, right, that you're talking about, that's governed by an abuse of discretion standard, correct? So that's
as far as this question goes, this is preserved.
How is it preserved?
It's preserved because when they were discussing this expert testimony, trial counsel argued that it should not be struck from the record.
Okay.
What's the basis for that objection, though, based on the fact that they were not there was no prejudice, as opposed to the constitutional issue?
No, I believe it was because they're.
In other words, you're saying the counsel below raised the constitutional objection at that time, and
okay.
Go ahead.
Right, I see what you're saying. As far as the constitutional issue, I think here, regardless, the counsel did object to this testimony being struck from the record.
But isn't more needed? In other words, a simple objection, you'd agree, doesn't cover it for purposes of preservation. It doesn't put the court below on notice, the parties below on notice as to what the objection is, right? There's no opportunity to cure at that point. In other words, it has to be a specific, more tailored objection in order to be covered. Isn't that right?
I would disagree. I think it's quite clear here that Mr. Emmons, that defense counsel objected to this testimony being struck from the record, that one of the reasons was because this testimony was so integral to Mr. Emmons's defense at trial, and that, defense counsel made his position quite clear to the judge that he wanted this testimony to remain on the record. And the
court, I thought at 208 to 211 of the record, he said his sole objection was that the people were not prejudiced by the failure to disclose the resume. So I thought he pretty much limited his requirement to prejudice and not any constitutional dimension.
That is certainly what he said on the record, and if that is what this court, how this court reads that, I would just ask that you consider this issue in the interest of justice, just because it is so integral to Mr. Emmons' defense.
Ms. Goldfarb, let's assume that somehow, some way we get to it, whatever mechanism, either it's preserved or interest of justice. It's
Correct.
still an abuse of discretion standard. And here, couldn't the defendant have easily avoided the issue by turning over the resume he ultimately testified that he had? Couldn't this issue have been readily avoided that way?
It certainly could have been avoided that way. However, not turning over the resume from the beginning, that's not really the end of the analysis. When you consider the value of this evidence to Mr. Emmons's defense, and the fact that as defense counsel argued to the court, the prosecutor had the opportunity to cross-examine Mr. Emmons regarding the information that would be found on the resume. And then because—
Counselor, aren't the people entitled to have that resume and be able to do whatever investigation or checking into what it says on that resume before the testimony occurs?
They certainly are entitled to that, but I think here it doesn't mean that the only remedy available to the court was to strike that testimony. As you said, yes, they would ordinarily do investigations about the information on that resume. And here, Mr. Emmons's testimony was at the end of that third day of trial. And the DA's office has a team of investigators, so they could have easily, after trial concluded for that day, made a few phone calls and inquired about the information that Mr. Emmons testified about, or the resume if that was turned over. And then, if necessary, continue to cross-examine him the following morning.
And counsel, that may have been an absolutely appropriate way for the trial court to handle that circumstance, and maybe even some members of this bench, when we were on the trial bench, may have handled it that way. But it's not how this trial judge handled it. And aren't we stuck, as Justice Curran appropriately mentioned earlier, with an abuse of discretion standard here? In other words, it's not a function of whether or not we might have done it differently, but our question is, did the court abuse its discretion in handling it this way as the gatekeeper of the evidence?
It certainly did, Your Honor. I think, here the court didn't really even exercise any discretion. It just chose to go through to the most drastic remedy of striking this testimony. It didn't consider whether there were any alternatives. And so I think this is certainly something that this court can and should consider.
Ms. Goldfarb, do you plan to address the Molyneux issue?
I can if this court has any questions regarding it.
No, I just wasn't sure if you were going past your first point.
Oh, yes, I was going to address the justification issue.
That's totally unpreserved, correct?
That is unpreserved, correct. But because of how integral, again, this justification argument was to Mr. Emmons's defense, I would ask that this court consider it either in the interest of justice or find that defense counsel was ineffective for failing to request this charge.
It's a high standard under the statute, right? The emergency measure is necessary to avoid imminent private injury, which is of such gravity that engaging in the conduct is more desirable than not engaging in the conduct. That's a high standard, right?
It certainly is a high standard, Your Honor, but here Mr. Emmons was in the back of the police car. His hands were handcuffed behind his back. The windows were open. He was struggling to breathe. He was also dealing with broken ribs.
He was able to breathe enough to kick the window. And he had some of his breathing difficulties were because he had a broken rib. It wasn't necessarily that the car was hot or that rolling the windows down or anything else would have alleviated his situation.
Your Honor, you are correct that he did have this broken rib. I think that exacerbated the situation. And so when you add that to the fact that he was in the back of a police car, the windows were up, the heat was on, it was a summer day, that certainly made it more difficult for him to breathe. And, as Your Honor mentioned as well, he had enough breath to kick the door open, but perhaps that was what he was doing with his last amount of breath. And he could feel that, if he didn't take action immediately, something more drastic and dangerous could happen to him. And, he has a contentious relationship with Officer Tybalt. He had asked Officer Tybalt to lower the window. Officer Tybalt refused. And so Mr. Emmons was in the back of this police car without any other options. This wasn't simply him flying off the handle, frustrated that he was dealing with the situation. If that were the case, he would have acted out much sooner than, in the back of the police car at the end of this whole, interaction. He could have, done something at the, when he was at court for the appearance, or when he was just waiting in the police car for Officer Tibble to come and drive him.
Counsel, I think we have that argument.
Okay, then if this court has no other questions, I rest on my brief for all other points.
Thank you.
Yeah.
Morning, Your Honors. Brad Osler again. I submit that I agree with the members of the panel that pointed out that with respect to the striking of defendant's testimony, that it is, at least the constitutional aspect of it was unpreserved, and that in any event, the court did not abuse its discretion. As the panel noted, this is the question of the value of the damage is I think the most critical issue at trial, given that the defendant admitted kicking the window. So the underlying intent or the facts of the matter were really not in question apart from the value. So I think the court's decision in light of the importance of that was appropriate. I'll briefly address the Molyneux issue. I think the most salient point here is that the defendant admitted to kicking the window, and if he were to kick the window, but not with the intent to break the window and hence open it or allow more air in, he wouldn't have kicked the window. The only reason you would kick it is to in fact break it to allow more air in. So I think defendant essentially admitted to the intent issue, which renders the Molyneux evidence offered by the people sort of irrelevant at that point in time. And I would agree also with the panel that the justification instruction, that matter is unpreserved and is somewhat belied by, as Justice Niemoyer pointed out, the other issues that were involved. It did not appear that the temperature of the car or airflow was really perhaps the most pressing issue defendant was facing at that point.
Counselor, wasn't there a video that was shown that sort of belied what was being claimed relative to the not being?
The video was, I believe, the forward-facing camera, but contained the audio from within the car, within the cabin of the car, and it did appear to, I think, somewhat contradict defendant's claims and supported Officer Tybalt's testimony. So again, I think that undermines the contention that a justification charge was in order. Unless there's any other questions, we'll rest.
Thank you, Counsel. Case 167, People versus Christopher Boyd.
Good morning, Your Honors.
Good morning, Counsel. Please proceed.
May it please the court, a statement cannot be described as voluntary where the very process used to assure that it's voluntary involves a police officer telling a citizen what to say. Today, I'd like to focus on point 2 of the brief as it pertains to the suppression issue of the statements. Turning to that issue, police interjection into Miranda warnings themselves are impermissible. We want to make sure that the defendant's decision to waive the right to remain silent is independent of any other external forces. What happened to Mr. Boyd was the very antithesis to being an independent decision or waiver. It can't be described as independent when the police officer told him he had to say yes to continue.
Counselor, there is a video, and in the video, when the question is first posed, your client is seen nodding his head up and down. So it's effectively a nonverbal answer. It's nodding up and down. And then he was asked yes, and again, he nodded up and down. And wasn't it then that the officer asked him to answer verbally? Wasn't he just confirming that what he was seeing was the communication being given?
There's conflicting accounts in the record the way I read it. First, the officer says following the second nod, his words were, yes, answer yes for me, will you please? Just so I know you're listening. And then my client answers yes. But then we have the suppression hearing in July, and I believe it's at page 82 of that transcript, or 86, when defense counsel is asking the police officer, would you even know if he ever understood? And he said no. So even the police officer didn't know here if Mr. Boyd was actually understood those rights.
Well, do you ever know when somebody answers yes, whether they understood it? I don't understand that part of it. To me, if there's two nods and you say answer yes, because that's what I believe you're saying, I don't think I'm ordering you or directing you to answer yes. If you've been shaking your head no, and I say you're saying no, I'm not ordering you to say no. I'm observing that that's what you non-verbally have communicated.
Well, I think it is telling someone what to say. If the officer had said, will you answer yes or no for me, so that there's an option, but here he said, answer yes. So this is a really precious right that someone's playing fast and loose with. And to say that the officer later on even said he didn't know if the client understood, I think that's dispositive too. So if there's no way to understand or comprehend whether he actually understood Miranda with either a head nod or no response, and the only option presented is to say yes, and with the police saying that they didn't know either, we have a problem. And this renders Miranda a nullity.
Thankfully, we have a video that the jury got to observe, don't we?
There was no jury in this case.
I mean, the judge got to observe. We had a video with the nonverbal communication, and you're saying the judge can't rely on that.
Well, actually, when the court went through its understanding of the record, its understanding was not correct either in its written decision and order. It just said that they just started chatting after he nodded. He said yes 2 times, which actually didn't happen. So I don't know how much we could give to that decision when it doesn't even accurately summarize what was in that video. And then we have the problem too, where my client was in pain and discomfort the whole time too. He had pain in the beginning, he had it throughout. The police officers noted it.
That pain was the result of what? Being shot in the ankle 2 weeks before?
4 weeks.
I don't know. I'm sorry. I'm sorry, Justice Winslow.
I believe the record showed it was 4 weeks earlier.
My mistake.
Yes, and also the officers noted some red marks. And the problem here too is my client did request medical attention, and it was usually in about 1 hour increments because the whole conversation or interrogation lasted about 4 hours. So about at 1 hour intervals, his condition keeps coming up. He's red, he has red marks. Whether the red marks are from the prior injury or from the police, there's still an issue that there is an injury and it's causing my client discomfort while he's sitting there shackled and handcuffed initially.
Well, that's contradicted by him saying, no, I'm cool. You gave me everything I needed, isn't it?
I don't think so. And I think that's obviated by later conduct throughout the statement that he gave. And even when the police officers weren't there, you could see when he was by himself, he was in pain. He was talking to himself about how much pain and discomfort he was in. So I don't think it's obviated by the fact that in a routine kind of thing that the police do saying, you got everything you wanted. I don't think that's really the dispositive issue here. And furthermore, the people bore the burden of, if there is an issue of injuries, they bear the burden to explain it. And it just wasn't even touched upon here. So the remedy in this case would be suppression for the invalid waiver and also the nature of the interrogation because of my client's pain. And unless there are any further questions from the court, I will submit on the remainder of the brief.
Thank you, counsel.
Thank you, Your Honor.
Counsel, proceed.
Good morning, Your Honors. Ashley Lowry on behalf of the people. Defendant here did not unequivocally and without qualification assert his right to remain silent. As Justice Winslow astutely pointed out, defendant was nodding his head in response to the Miranda rights as read to him. The soft-spoken defendant made an inaudible remark after which the senior investigator simply clarified whether the defendant had listened to and understood the rights, as the Miranda card says. The senior investigator simply clarified whether defendant had listened to, understood those rights. Defendant said yes. He wasn't forced to say anything. The senior investigator confirmed again and asked if defendant was willing to speak with them, after which defendant did not say no, did not indicate physically a refusal, did not make any indication to stop the discussion, which the conversation was almost 4 hours long. Here, the defendant did not also display any outward signs of discomfort. I believe it's the 5th question in at the start of this conversation with the police. He was asked, "Are you injured?" And he indicated no. While it did come up during the course of the interview, he wasn't specifically asking for anything. It can't be expected. The police cannot be expected to know what it is the defendant needs or is saying unless he's expressing it to them, verbally, non-verbally, whatever. So here, though the defendant was soft-spoken, his physical demeanor took on a conversational tone. He wasn't showing any signs of duress or undue influence. The police did not make any threats, promises, or use coercive behavior. I would submit that the court's determinations are supported by the record, and I'd ask that you affirm. Thank you.
Thank you, counsel. Next case up for argument, case 174, New York State Division of Human Rights versus Ronald Hawk, Big Money Gym Inc. et al.
Good morning, Your Honors.
Morning, counsel. Proceed.
May it please the court, Tony Ann Hollifield for the Division of Human Rights. The division's commissioner found the respondent corporation and its owner, Mr. Hawk, liable for subjecting Ms. Paust to a hostile work environment based upon her age and sex and for the constructive discharge of her employment.
And you would say, Counselor, there's substantial evidence in the record. We should review it, sustain the finding, and find further. I suppose you would argue that not only is Mr. Hawk is personally liable because he was personally involved and also the owner of the business, but also, if I understand it, the damages analysis you have shows that what was awarded was right within the range that is ordinarily awarded and that the courts have upheld, right?
That's correct. The division's commissioner awarded $10,000 in mental anguish damages and a $3,000 civil fine and penalty was assessed. And those are in line with previous awards.
I think we have your argument, counsel. Is there anything further?
No, thank you.
Thank you. Case 176, Hint versus Hint. Counsel?
Good morning. I'm sorry, there was a delay in my, good morning, Your Honors.
Not a problem.
May it please the court, Emily Vella on behalf of the appellant. My argument is set forth in my brief, but I just want to reiterate the fact that in terms of imputation of income here, I believe that there needs to be some basis in the record and in the facts that were submitted into evidence in the court with respect to the earning capacity of my client. And there simply lacked that in connection with this case. In that,
wasn't the number taken from his last filed tax return?
I'm sorry, Your Honor.
Wasn't the number of $54,995 taken from his last reported gross income on his federal tax filings?
But that was his gross receipts, Your Honor, in terms of his farming business as well as his the logging of timber on his farming property and also the sale of animals. And I believe that I articulated in my brief that with respect to the logging of timber, that wasn't some recurring expense. It certainly wasn't articulated in prior tax returns that was a number that he had every single year. And that was to the tune of $17,000 that he
Counsel,
did.
but a lot of that's going to depend upon your client's credibility in testifying. And didn't the court indicate that your client's credibility was called into question? I think the court indicated his testimony was not convincing, or words to that effect.
I understand that the court did indicate that, yes, Your Honor, but I believe that the evidence that was submitted to the court showed what his income was, what he was earning, the inability for him to secure any further employment based upon his age, based upon his educational record, and based upon the fact that the income producing sources were no longer existent, Your Honor.
I think we have that argument, counsel. Anything further?
Thank you. No, Your Honor.
Mr. Williams, you need to unmute your, very good. Thank you. Proceed.
Thank you. Good morning, and may it please the court. The record is absolutely clear that the representations made by the defendant, both with respect to income and with respect to expenditures, are not reliable. I mean, he's claiming expenses that so far exceeded what he was earning, that there were times when it would have been absolutely impossible for somebody with no savings and with no credit expenditures that could possibly explain the shortfall. He was very evasive with regard to, what did you report as your income on this application? Well, I didn't write an application. I didn't write down what my income was on an application, but I got financing for these 2 cars anyway. I mean, it is.
Well, didn't he actually admit that he claimed expenses for taxes on the property that his son lived rent-free, even though the agreement with the son was that the son paid such taxes on the property? So he basically admitted that he was wrong and misleading the court about his expenses.
He admitted to some extent, Your Honor, that is true. He did admit that the 2018 taxes claimed expenditures that were in fact paid, included expenditures that were in fact paid by his son, but it goes so much deeper even than that, truth be told. And when the court saw that he was willing to be dishonest even about those things, it was something that strongly supports the determination of credibility. A reference was made recently to prior tax returns. It's very interesting. One would assume invariably any farmer will have yearly expenses for fertilizer, lime, utilities. Certainly he sometimes claimed for that. In all of 2017, according to him, when he's reporting a net income of $131, zero for that. It's part of what goes to the overall credibility. There were so many different indications of him having things to hide, where he's not saying what he must have reported on occasions when he would have had to report an annual income. The only possible reason for that is that he doesn't want the court to know what he was saying about what he had said he was earning. It's really not a matter of speculation. And when the party's account is not believable, which is a matter as to which deference is owed the determination of the trier of fact, the court may impute a true or potential income higher than alleged. And I might add, it's not just that the court took exactly the same income figure from the 2018 taxes. The court, in using that figure, did not even take into account what it specifically said it could. The income producing capacity of the 3 parcels of real estate combined worth a little bit under $300,000, $298,000, I believe. That's not even taking that into account. And furthermore, with regard to the court not taking into account the expenditures with respect to logging and the loss of the animals, I don't believe that there was any corroboration of his claim that I don't have any more of this to log, with the exception, possible exception, of the implied corroboration of the document created by him, where he is putting the figure for all of that into the January column for 2018 in Defendant's Exhibit O. Even that, though, because it comes from him, presupposes credibility on his part, which has been demonstrated by flagrant inconsistencies between that document and his statement of net worth to be just non-existent. And with regard to the animals, he was at that property every day to take care of the animals. Then he pulls back a little bit saying, well, if I wasn't there, then my son was there. And he is not doing what needs to be done in order to rectify the situation. And nobody corroborated his claim that the ground, you couldn't bury the animals, that the tractor wasn't working. I didn't see any corroboration in my review of the record with respect to that. The court was not required to believe the claims that he was making. And in any event, it was not justifiable, so far as one can tell, for him just to leave the animals where they were and then to be confiscated.
Very good. Thank you, counsel.
Thank you, Your Honor.
Case 178, the matter of Andrew DeWolf versus Jamie Sirrett and the Wayne County Medical Director. Very good. Welcome. Please proceed.
May it please the court. Good morning, Your Honors. I'm Andrew DeWolf, I'm pro se litigant. It's my first time arguing before you. I wanted to start off, Your Honors, saying that the respondents contend that this is about patient safety. And I wanted to raise that Public Officers Law Section 16 already has a statutory process for immediately suspending and addressing unsafe EMTs and paramedics in the state. In 1401, the policy that I'm asking you to strike down violates that process. I wanted to point out that the agency medical directors, REMAC, in the state already have this process for summary suspension. And so by striking down policy 1401, as I ask you, this court will not undermine public safety or the ability of the local agencies and regional agencies to address safety concerns. I'd also like to immediately and adamantly deny that I'm a danger to patients. I'd like to point out that the medical director himself affirmed this to the state of New York. It's in the record on June 24, 2019, and a notice he wrote to the New York State that I had not harmed any patients. I'd like to point out that 19 months later, that affirmation has not changed, and no charges have been filed against me by state officials or the REMAC or Wayne County after a 19-month investigation. I'd like to point out that if I was so unsafe, then why didn't this QA committee catch this after 18 months? Why did this take 18 months for them to say that I was grossly unsafe? And they didn't go back. They retroactively went back and looked and found what they called technical violations. I'd like to point out in the record, Dr. Surratt has affirmed in his affidavits that he is timely appraised of all protocol violations in the system. And I posit to the court that that means that this QA program, which I whistleblower raised major concerns about, needs to be reviewed. There were no concerns until after December 14th, 2018, when I put in another whistleblower complaint using a grievance. And then, pardon my language, Your Honor, all hell broke loose. Even then, in January, via 2 phone calls, one of them withheld from the court in the record, Dr. Surratt affirmed for me twice that I had no QA issues whatsoever. I had a clean QA record. He told me if that changed, they would bring this to me. I'd like to point out to the court that I have been remediated. I took the entire New York State paramedic class twice, once online, once in person, Your Honor. And I'd like to reiterate, the New York State Department of Health's had this 19 months now and have filed no charges, found nothing so far that they brought to me that's been sustained.
Mr. DeWolf, let me interrupt you for a second. Could you address the issue of exhausting your administrative remedies? And there was no appeal, was there, to the Department of Health Commissioner in this case? And wasn't there a need for that to happen?
There were 3 or 4, Your Honor, appeals to this. Only one of them were put into the record for you, and that was by my attorney in October of 2019. There were a total of 4 appeals to the State Department of Health, and Wayne County itself affirmed on March 9th, 2019 in writing to the Department of Health that all appeals have been exhausted.
Exhausting the administrative remedies, it seems to me, may require that the Commissioner of Health or the Commissioner of the Department of Health has a final resolution of this, has an appeal brought to them, and they resolve it. I don't see anything in the record that reflects that happened. Are you saying that it happened? It's just not in the record?
I'm saying the Department of Health refused to hear the case ever, Your Honor. They refused to take it up, and they had 3 opportunities to do so, and they've never reviewed it and weighed in on it. They've let it go. They've constructively denied it.
Okay. Anything else?
Yes, Your Honor. If you'll indulge me, I do have a few other points for you on it. I'd like to raise out that we have an issue here of what I call traps in the law, if you will. We were struggling. Our contention is that the final agency decision was the one that Wayne County made on June 24th, 2019. And so therefore we have a 4-month statute of limitation to get this into the court to get it preserved, and then have it argued with the court whether this was whether there really was a legit appeals process to go through. And I contend that under the exhaustion argument, Your Honor, that the Wayne County's decision on June 24th was a final decision. And the reason I say that is because Wayne County, if they're applying Section 3004A of Public Health Law, which they argue that they were, then there was an injunction placed on them. While there was an appeal in process all the way up to the commissioner, they couldn't take any further actions. And they continued to take further actions. They moved for termination. They continued to suspend. They took additional stuff. They declared that I was absolutely fired and terminated, and they proceeded forth. So therefore, the June 24th decision was a final action, or they couldn't have proceeded any further to argue it. They couldn't have taken it on to the commissioner. And I would also argue that there were, like I said to you, there were 4 appeals to the commissioner. The commissioner never took it up. They had January, March, and I believe June meetings.
Counselor, what do you mean they never took it up? Did you get any response from the Department of Health that they denied the appeal or that they weren't going to hear it? Or your argument is that you did file something and you never heard back from them?
2 things, Your Honor, respectfully. I received nothing from them, but on the video.
Did you take an appeal?
I don't understand, sir. Sorry.
In other words, did you request that an appeal for an appeal? Did you ask them for an appeal?
Yes, sir. 3 times.
And then you're saying that you never heard back from them?
That's correct, Your Honor. Plus my attorney filed once.
Okay, I think I understand. Thank you.
And then the state EMS representative, Your Honor, Jack Davidoff and Jason Hagg, they came back and reported on video, on public video, that the state wasn't taking this up, that they were letting this play out in the process. They weren't going to do anything with it.
Okay, you should begin to wrap up, Mr. DeWolf.
Your Honor, I do have 2 more points if you'll hear me out on it. I wanted to take your eyes to a case, the U.S. Supreme Court case, Yickvo versus Hopkins in 1886. And I wanted to ask you to take a look at that in the context of this case, Your Honor. There's a reason that this public health law is in place, and there's a reason you all have concerns. You want to make sure an unsafe paramedic can't practice, and there's a measure to take up for that. But you also want to make sure that when it comes to balancing whistleblowers and major concerns and unsafe paramedics, that one guy who's compromised in this, because the stuff I was raising compromised the agency, it compromised the medical director, it compromised the REMAC, and it compromised state officials. You want to make sure that one official by himself can't put in something to suppress me, take me out, make sure my complaints are never raised, have it be applied statewide without going through like a court like this with due process. And 1401 doesn't do that, Your Honor. 1401 intentionally makes sure that a single agency medical director can throw this in, can have it be reviewed by his peers that are fellow compromised, and then have it be applied statewide. And if you look at the enactment procedure in 1401, you'll not only see that they say that in there, but in 2016, SUMSCO Representative Jason Hagg and Jack Davidoff both affirmed that they intended 1401 to be a statewide thing, that if it's put in by one medical director, it's enforceable statewide. You can't work anywhere, you're blackballed anywhere, and you have no right of appeal on this except through their own friends and peers. That's not due process, Your Honor, and that definitely doesn't support public safety for raising whistleblowers. And one final one, Your Honor, I'm sorry, I was trying to be prepared for you. I also wanted to raise, Your Honor, that Wayne County itself has contradicted itself in sworn testimony that in 2 parts. First of all, the medical director clearly threatened that this was a fight to the death over these whistleblower complaints and grievances. This was his words, his statements, these were not mine. He said, I may win this battle over the initial grievance and whistleblower, but I'll lose the war. This is about retaliation and constructive discharge. I also wanted to point out that Wayne County itself is in sworn testimony on June 2nd, 2020, affirmed that New York State policy statements are not law. They're guidance statements, they're advisory statements. And the reason I asked this court to ponder that and consider that is part of what I raised under 75B protection was that these guys were grossly violating a long list of policy statements of the state. I thought that they were law too. And the state turns around and says, or the county turns around and says, no, we weren't violating them. They're not law. They're only advisory statements. You can't do anything with them. We can do what we want here. Your Honor, both sides of this argument can't be true. They're either law or they're not law. And if they are law, then everything I raised was true and everything that I said was happening illegally was happening. But now you're turning it around in my case and you're saying, well, 1401's law, but it only applies to you, not to us. I had one more point I wanted to raise. I apologize, and I know you need to be out of here. I did want to point out, Your Honor, and I want to summarize with this. You're going to hear Mr. Youngs talk about public safety and that this is about whether I'm an unsafe paramedic practice, and Dr. Surratt is the expert. There's no denying that. So my question to this court to ponder as we wrap up here is, if this court found so many violations of me after an 18-month investigation, when I said, hey, this QA process is invalid, you're not following public health law section 3006, we don't have a properly formed QA committee, we're not doing stuff right, we've got disparate treatment, we're ignoring major violations that led to harm, which, Your Honor, we are talking about actual harm to patients that I raised. And I said, if you're missing all of this, and you said that you went back 18 months to find mine, then there's some valid concerns about that QA system. And there are valid concerns about what they raised to you regarding me. And if you're finding this many issues about me, it affirms that the issues I've raised are legitimate and that this system needs to be fixed and addressed. And I have more to say, but I'll let it go there. Thank you, Your Honor.
Thank you, Mr. DeWolf. Counsel, proceed.
Morning, Your Honors. Jim Youngs on behalf of the respondents, Wayne County.
Counsel, would you begin with the exhaustion of administrative remedies issue?
Certainly, Your Honor. The administrative appeal process is set forth in 1401. If a service provider wants to challenge a patient care restriction by a medical director, he may challenge it, appeal that to the REMAC, the Regional Emergency Medicine Advisory Committee. If he does not have a satisfactory outcome there, he may appeal it up to the State Emergency Medical Advisory Committee. If he does not have satisfaction there, he can appeal it to the Department of Health.
Okay, so I think it's your position that the REMAC decision was not appealed to the CMAC. That makes sense? Okay. Tell us how we can figure this out from the record here.
Your Honor, the petitioner indicates in the petition that he had appealed to CMAC, and there's nothing really more in the record as to what CMAC did or didn't do. That's within the petitioner's control.
Was there some argument, at least from your perspective, that the appeal to CMAC took place subsequent to the filing of the petition here?
Your Honor, I don't have any information, and there's nothing in the record about proceedings before CMAC.
Okay.
You know, frankly, it is.
Counsel, just so I'm sure, though, the court found other reasons besides exhaustion of administrative remedies. So that's an alternative theory that you would like us to affirm the court. But you believe there's other reasons? Could you just address those briefly, that we should affirm the court's decision?
That's correct, Your Honor. Really, the exhaustion is a tertiary argument. The primary issue here is the petitioner's claims in this case are all centered and arising around employment matters that are subject to mandatory arbitration pursuant to a collective bargaining agreement and in accordance with the civil service law. Retaliation, whistleblower issues, the issue of his termination, all of these are covered by the CBA, as all parties acknowledge. And he said just now, this is all about retaliation and constructive discharge. That is a process.
I guess I'm more concerned. The court below found that the policy statement 1401 was valid. You believe that was correct because it was a legislative enactment. The court also found that the patient care restrictions had a rational basis. You believe that's supported by the record?
Absolutely, Your Honor. And the issue here, the sole issue on this Article 78 is whether the patient care restriction issued by the medical director was arbitrary and capricious. And the lower court was correct in holding that it was not. It's well-reasoned, extensively documented, and moreover, it was the application of the medical director's professional medical opinion as to the safety of the petitioner here.
Which is entitled to deference by the court.
Absolutely. This court knows the Article 78 standard very well. It applies with even greater force in a technical, specialized area such as medicine. The courts do not supplant the medical judgment of an emergency of a physician for its own judgment, even if it might come out in a different way. So absolutely, beginning and end of this case from our perspective is that there was no arbitrary and capricious application of an official decision. that should be the end of the story. As to the enforceability of a policy statement 1401, it has the authority of law behind it. It is part of a very comprehensive, multi-tiered, interlapping regulatory scheme, from the DOH down to a state emergency council, to a regional emergency council, all the way down to an on-the-ground medical director who is authorized by the law to be and is obligated to be the medical control for the medical services provided by that EMS agency. And a critical component of being a medical control is patient care restrictions. And that was, that policy statement was provided by CMAQ and by the DOH, pursuant to its own authority and obligation to provide that detailed level of what an agency medical control has to do. And this is where the rubber hits the road. That doctor is on the ground seeing the care being provided. That doctor has to be able to impose a patient care restriction independent of any employment issue, because that's going to get sorted out, and it is being sorted out. Still, here 18 months later, the petitioner is still employed, still embroiled in extensive arbitration pursuant to the CBA, now bringing a litany of charges before the Public Employment Relations.
Counsel, not to cut you off, your understanding is we have before us the Article 78. You want us to believe and want us to affirm the judge's decision.
That's correct, Your Honor.
Okay, I get that.
Okay. So, and without belaboring the point on 1401, ignoring or striking down policy statement 1401, or otherwise limiting a medical director's ability to impose a patient care restriction is a very serious matter, could potentially be a dangerous precedent and undermine a critical underpinning of the statewide, all the way from the top down to the bottom, regulation of EMS services. And finally, Your Honors, I would just say, and be open to any questions. There are allegations that, you know, this imposition of the patient care restriction impacts the petitioner's due process rights. That is not the case. There is a separate proceeding, many separate proceedings pursuant to the CBA going on about his employment. An EMS provider does not have a constitutional right to see patients. In fact, patients have a right not to be seen by a paramedic who has been deemed to be a danger to them by the regulatory authorities. So I would leave it at that, and happy to answer any other questions that the court may have.
Thank you, counsel. Mr. DeWolf, I've noticed you tried to get our attention, but we do not allow rebuttal in arguments. So thank you, sir, and thank you.
Thank you, Your Honor.
Case 179, Didis versus Rochester Gas and Electric Corporation. Very good. Welcome, counsel. Please proceed.
May it please the court. Good morning, Your Honors. Stephen V. DiBraccio from Burke Scolomero and Hurd on behalf of Appellant Defendant Rochester Gas and Electric Corporation. 3 points today. First, to discuss the sole proximate cause and recalcitrant worker issue. To just quickly go through the Bianca-Nato factors, Supreme Court erred in denying defendant summary judgment motion and granting plaintiff's cross motion for partial summary judgment on liability. First, there were adequate safety devices available. Lauren Chilton was plaintiff's co-worker working right next to him, doing the same work, finishing concrete, and he used knee boards, which allowed him to not have to work on top of the plywood board on which plaintiff fell through a hole. It is clear that plaintiff had access to the knee boards.
Mr. DiBraccio, good morning. It's clear that this plywood covered a hole, correct?
Yes, Your Honor.
All right, and it's clear that the plywood was unsecured.
It is undisputed, Your Honor.
So how would the knee boards have protected the plaintiff from an unsecured plywood board covering a hole in the direct vicinity of the plaintiff?
Yes, Your Honor. Well, I think the key phrase there is direct vicinity. There was testimony, and I'm blanking on whether it was Chilson or Barber, but there was testimony that using the knee boards, they were able to finish the concrete on their knees and use their hands, and instead of having to step. And so therefore, he would not have had to step on the plywood. He would have worked around the plywood, but not on top.
So counsel, you're not arguing that the knee board somehow acted to secure the plywood or somehow acted to cover the hole?
That is correct, Your Honor. I'm not arguing that.
Okay.
And to that point, Your Honor, I also want to bring up, I am not arguing that the 12 instructions he got to not stand on the plywood board is a safety device. Defendant acknowledges that an instruction is not a safety device, but this is not about the instructions. This is about the fact that the knee boards were right there. Second factor is plaintiff knew that the safety devices were available and he was expected to use them. Respondent argued in his brief.
I still don't understand how the knee boards protect him from falling in the hole that he's required to work in close proximity to.
They protect him from not having to be in as close proximity such that the hole is a risk to him. He doesn't have to be close enough where he is in danger of.
Isn't your argument?
Your contention is the failure to wear the knee boards was the sole proximate cause of this accident, not that the plywood wasn't secured or that there was a hole. It seems there might be multiple reasons for his fall and injury.
Simply put, Your Honor, yes, and this is demonstrated by Chilson's testimony that because Chilson was working right next to plaintiff, used the knee boards and did not fall through the hole. Had plaintiff used the knee boards, he would not have been in proximity to the hole and would not have fallen through it.
All right, I think we have that argument, counsel.
Just briefly on one more thing on the sole proximate cause, Your Honor. Experience matters. Respondent argued in his brief that it was plaintiff's first day back on the job site. Respectfully, Your Honors, he was a foreman. He had worked for 8 years at the time of the accident. It was not his first day as a construction worker. And this court and the Court of Appeal.
Isn't that more of an issue of comparative fault, Mr. DiBraccio?
No, Your Honor. At best, there are triable issues of fact as to sole proximate cause. Because the knee boards were there, and get tandem with the instructions and his work with Chilson, this rises to the level of sole proximate cause.
We'll consider that, counsel. Anything further?
Yes, Your Honor. Number two, the Bragi argument that Labor Law 240 does not apply. And in large part, it does.
Mr. DiBraccio, on that issue, I was somewhat surprised you didn't discuss a rather recent case of McKay from, I think, 2016, and our presiding justice was on that panel. And there we went the other way on this issue, I thought, with respect to the hole. And so you don't even talk about McKay and its significance to our case law in this area, do you, in your briefs?
I'll take.
By the way, your brief was very comprehensive. I'm not faulting you, but when what seems to be kind of a key case in this area is not addressed, maybe there's a more strong argument that you have on number three, perhaps.
Okay. Number three is simply that Supreme Court should have granted defendant's motion as to Labor Law 200. There was no tribal issue of fact that, first of all, it's a means and methods case, not a defective premises condition case.
Isn't the whole a defective condition or defective premises?
Respectfully, no, Your Honor. It's the plywood board in tandem with the hole, and that is not a defect inherent in the property.
But the hole is a dangerous condition that needed to be secured. So it's not a manner and means. It seems it's a dangerous condition case, isn't it?
I would agree, Your Honor, if it was a hole only, but the concern here is how defendants and power the means and methods of the work in securing the hole.
Well, you wouldn't disagree that it flows from the property. you're suggesting that even so, it's not, even as it existed, it's not a dangerous condition? That's what gets you outside of that?
My argument, no, would be that if it was a dangerous condition, there's insufficient evidence of control over that area. I know plaintiff raised the issue of constructive notice, and I do concede that defendants had constructive notice, but defendants did not have control over that area.
DeBraccio, you should begin to wrap up, sir.
Yes, Your Honor. Two housekeeping points, Your Honor. Supreme Court should not have searched the record to grant partial summary judgment as to Labor Law 241-6. This court has stated that Labor Law 241-6 finding is only evidence of negligence, so a summary judgment could not be granted. And in any event, tying back to point one, there are at least tribal issues of material fact as to whether plaintiff was the sole proximate cause or a recalcitrant worker. Thank you, Your Honor.
Thank you, counsel. Counsel, proceed.
Thank you. May it please the court, Jason Paselovich here for the respondent. I was happy to hear Mr. DeBraccio say that an instruction is not a safety device, but I do want to point out that I want to clear up the record. First of all, my client was not told on 12 other occasions not to step into this or onto this unsecured hole. That was the first time, January 19th.
But Counselor, even if he was, according to your opposition, it doesn't matter, right?
Understood. I just wanted to make sure that I don't understand where that particular assertion came from. So I just wanted to clear up the record if I could. Insofar as the knee boards being a safety device, I think it's very, very clear that Section 240, a functional equivalent of a safety device is not a knee board. Section 240 outlines what a safety device would be. Would it be hoists, slings, scaffolds, etc.? I cited some cases where
Counselor?
Yeah.
Counselor, would a knee board provide him with any protection from the elevation risk?
It wouldn't, because he was required to work on or around the unsecured opening. So he was, at the time he fell, he was smoothing this concrete right around the metal frame, which was where the plywood was laying on top of. And he also asserted that he couldn't use the knee board at that particular time anyway, because the concrete itself was too wet and soft and unformed for him to even use it. A knee board is really just a tool in the concrete smoothing process, but you have to wait until the concrete is sufficiently hardened to the point where you can actually kneel on the board. And
Counselor,
yeah.
Your opponent referred to the testimony of Mr. Chilson and said that he used the knee board, but when he was using the knee board, the concrete was harder. That'd be accurate.
And he was correct, and he was in a different spot. And Mr. Chilson also conceded that the knee board can only be used at a certain point in time during the concrete finishing process. My client wasn't even there yet. He was still smoothing or floating this concrete that had just been poured. So he wasn't even the tool, not the safety device, the knee board, but the tool, the knee board, was not even available to him at that particular time.
Okay. Anything else, counsel?
Yes, insofar as the Section 200, Your Honors, I think it's clear that the defendant had awareness of a defective condition on the property. They had a project manager, Mr. Kuiper, that was there several times per week. They were well aware of this defective condition, and I would agree with the panel that it was in fact open and obvious, and therefore there is a triable issue of fact on that. Insofar as the 241-6 labor law claim is concerned, I would respectfully request that you affirm the lower court's finding granting summary judgment. We cited case and regulation in our brief, which indicated so long as the hole was of sufficient depth and size, 241-6 prima facie case for 241-6 would apply, and the lower court properly found summary judgment for that section of the labor law. We ask that you affirm that as well. Unless there's any other questions, that's all that I have.
Thank you, counsel.
Thank you.
Case 180, Patricia Vanderhoff versus Ford Motor Company et al. Counsel, welcome. Please proceed.
Good morning, Your Honor. May it please the court, Mark Whitford for the defendant liquidating Reichhold. Your Honor, in the first instance, we would submit that the trial court erred in concluding that the defendant did not meet its prima facie burden in moving for summary judgment.
Mr. Whitford, let me see if I can frame the issue for you, if I could.
Sure.
You're really relying on this propositional law that when a plaintiff fails to name a defendant as a supplier in an interrogatory response, that could equal an admission that the defendant did not supply the particular product. And you want us to look at the responses to the interrogatories, specifically that the plaintiff's attorney answer those interrogatories by saying the identification of the defendant's products may be established by coworkers, so to speak, in the future. And also it will be established through invoices from the defendant to the manufacturer, and then another general proposition that upon information and belief, your products did contain asbestos. So you're suggesting that doesn't meet out anything, that doesn't answer anything, and therefore it's equivalent to this admission under the case law. Is that correct?
That's correct, Your Honor. In essence, that is our argument, is that, we're essentially trying to prove the negative in this case, that our products were not the products to which the decedent was exposed. And to do that, we engaged in targeted discovery, and we served interrogatories. Those interrogatories were not only lacking in form, they were not signed by a party, but they were signed by the attorney. But more importantly, they were lacking in substance. The purpose of the interrogatories is to identify evidence. That's what the defendant has to do to prove that something did not occur, is force the plaintiff to identify what evidence they intend to rely upon. And they did not, identify any evidence.
Okay, what about the idea that do you say that it's game over? What about the evidence that, or the proof put in an opposition as to suggest that your products were there, and that this particular plaintiff did engage in some activities where there was dust, etc.?
Your Honor, first I would say it's not game over. We certainly submit that the trial court was wrong in saying we didn't meet our burden. There was an absence of evidence through discovery in this case, and we met our burden. To your point, then the burden does shift to the plaintiff to identify a tribal issue of fact. And I would submit that this is where this appeal truly lies, is the evidence, is there enough circumstantial evidence to show and demonstrate that the other causes of the decedent's injuries were so remote that the jury wouldn't be left to speculate? And we would submit, Your Honor, that you couldn't do that here. The witnesses that were offered, they identified 10 other suppliers who were supplying asbestos-related products to this facility. And specific to the process that the decedent was involved in, there was at least 5 different suppliers who were involved. And we would submit, Your Honor, that's the real issue in this case, that they've identified a number of defendants who were supplying products involved in certain processes, and they're asking that it just be left to a jury to surmise, speculate, and guess that it was the defendant's product to which the decedent was exposed. And we would submit that's not sufficient.
Is your argument twofold? In other words, how much of this product was used during this period? And also whether this individual was even present where the product was?
I don't submit that that's the sole issue, how much it is. We offered evidence that during this relevant time period, the amount of products that were being supplied by our client were decreasing quite significantly. But it's in combination with the fact that there's 9 other suppliers at this site. And this court has held previously that merely having the products on site is not sufficient to find that the defendant is liable. And here,
you disagree that your product was used in the manner of the testimony by this individual. I forgot whether it was Mr. or Mrs. Kensington.
I'm sorry, Your Honor, I didn't catch all of that, but
as I understand, there's a little deliberation here. So I hope you can understand, or I'm clear. My understanding is your, at least according to the plaintiff, your product is is used to melt down, make handles like for the old Revereware frying pans. In other words, those black handles, I would assume. And then once they come out of the mold, they put them into this machine. It's sort of like, what you use in a commercial kitchen. You got the big potato, you throw those potatoes in and it grinds them around and it takes the peels off, grinds them down. That's what they say. And that this created some type of dust, and then there was some blowing off of this dust, and that's how he was exposed. Are you saying that your product was not used in this process? Or are you saying that they haven't established it was used enough, or that this individual wasn't exposed and therefore it's pure speculation?
It's really the last item you said, that the plaintiff's burden is to identify that the decedent was exposed to the defendant's product. That is the standard. Our position is they haven't done that. Could our product have been one of the products that was used in the process? Possibly, but the same witness testified that there was at least 4 other products that were used. And so our position is you're leaving it to the jury to purely speculate that our product was one of the 5 and that he must have been injured through the use of our product.
Well, counsel, just so I'm clear with your argument, and I think I'm getting it, that you're not. There's no argument that the former foreman testified that he identified your company's product as being asbestos-related product that was being used at that time. You're simply saying that there's no direct evidence that this plaintiff was exposed to your client's product directly, that he could always have been exposed and only exposed to other parties' products. And as long as that's a possibility, it's too speculative for a jury to decide. Is that your argument?
In some ways, Your Honor. I mean, to be clear, Kenworthy, who testified, did not even mention the decedent. He didn't mention him at all. He talked about the process. You are correct that it did identify Reichhold's products as being used on site. That's never been disputed. He talked about them being used in the process of making these pan handles and the tops. That's undisputed. What the issue is that it's certainly not exclusive by any means. He did not testify that Reichhold's products are exclusively being used, and then you have evidence that the decedent is involved in this process. It is clear that you have multiple suppliers, and you're just leaving it to the jury to guess and to speculate. And that's where we believe this court has issued guidance that circumstantial evidence is permissible so long as the other causes are sufficiently remote.
So you're saying the burden is on them to demonstrate that the plaintiff was only exposed, the plaintiff decedent, I should say, was only exposed to your client's asbestos-related materials and not to others. And if they can't demonstrate that, you're out?
And I don't think that's the standard, Your Honor. I don't think it needs to be only to establish it's only ours. It has to. The case law, including this court, has said there has to be a reasonable inference without relying on speculation and surmising that the defendant's product was involved. And we would submit because in this case you have 5 different suppliers involved in the process at issue. That's exactly what you're asking the jury to do. You're asking them to just guess and suspect that it's the defendant's product as opposed to any of the others that are involved in the process.
I think I understand your argument, counsel. Anything further?
Unless there's any other questions, Your Honor, I'll rest on my brief. Thank you.
Very good. Counsel, proceed.
Yes, good morning, Your Honors, and thank you for your time. I'd like to address those points in reverse order if I could. So starting with the plaintiff's evidence, then going on to the prima facie burden. It's true that there were 5 suppliers here who were supplying asbestos that was used for this particular application. However, the standard is not showing through direct evidence that there was, a witness saw Mr. Vanderhoff specifically exposed to the defendant's products here. In the Oken case in the first department that I cited in my brief, I think is dispositive of this question. There was a case where there were multiple suppliers. The product was used interchangeably, and the plaintiff was frequently exposed to asbestos dust from the work. And we're also talking about summary judgment here, where reasonable inferences are to be drawn in the favor of the plaintiff. And I believe that when you look at the record evidence that the plaintiff submitted from Mr. Kenworthy, saying from 1974 to 1978, I was the plant manager. We ordered over 1 million pounds of asbestos phenolic molding compound from Reichhold. We used that to make pots and pans on the Wheelabrator machine. I did that work personally. I was regularly exposed to asbestos from that work, including from these over 1 million pounds of the product that we received from Reichhold. And then you had another witness, Miss Whaley, who testified that the decedent, the plaintiff, Mr. Vanderhoff, was working on that same machine, doing the same work during the same time, exposed to asbestos in the same way as Mr. Kenworthy. And don't forget that Mr. Vanderhoff was not there for 5 years. He was there from 1963 to 2003. It would be, in my view, unreasonable to conclude that Mr. Vanderhoff was never exposed to Reichhold's product. That would be speculative and also against the First Department's persuasive, of course, to this court view in the Oken case. I really just think that the testimony of Miss Whaley, coupled with Mr. Kenworthy's testimony, creates obvious questions of material fact that need to go to a jury, and that's what Judge Del Conte found below. But going back for a second to the prima facie burden, I think that's important because there was an identification here, and I think the real issue is with, how specific was that identification? The reason I say that is defendant cites to this court's ruling in the Gorska case in 2006, where the court found that the plaintiff's failure to identify the defendant as a source of the movement, in that case, as a source of his asbestos exposure was dispositive. Now, what happened there is in response to interrogatories, the plaintiff did identify over 50 specific defendants, specific companies that exposed him to asbestos. But the movement defendant was not one of those companies. It was omitted from that list. So that was construed as an admission that it was not one of the suppliers. We asked you who the suppliers were. You listed.
Your responses, your point is that the responses to the interrogatories didn't do that. They just suggested that we are going to establish it, and we're going to establish it through coworkers and also through invoices, and ultimately at least have some proof as relates to that. So in your view, the defendant didn't meet their burden in the first instance, and if they did, based upon your first argument where you started, at the very least, you created a question of fact.
Yes, that's correct. And Justice Carney, on that first point, I would just point to the record at pages 70 and 84, which are the interrogatory responses where the plaintiff's counsel, I concede that point. It was not a sworn response, but plaintiff's counsel identified asbestic phenolic molding compound suppliers to the dye molding plant as a source of plaintiff's asbestos exposure. And that identification should have made the defendant, who clearly was supplying asbestos molding compound during that time to the dye molding plant, aware, or at least able to reasonably infer, that its product was the source of the plaintiff's exposure. And then, yes, it's true that was, and the other quick point that I'll make on that is Mr. Whitford kept talking about evidence in terms of the interrogatories being evidence. But this is a motion for summary judgment. It's not the standard that a plaintiff needs to come forward with affirmative evidence to preclude the filing of a motion for summary judgment. What the movement has to do is come forward with evidence in admissible form showing that its products couldn't have contributed to plaintiff's exposure. And it didn't do that. It took a problem with the interrogatory response, but I would submit that the identification was appropriate and was sufficient to trigger the submission of some evidence from the movement. They didn't do that, but then again, even if they had, our evidence in response creates a triable question of fact for the jury.
Thank you, counsel.
Thank you.
Court stands in recess. Sine die.
And the panel will